welcome to Law and Crime, and now we're taking you to Orange County, Florida, where a defendant will now have to represent herself in her own murder trial. This is the case of Sarah Boone, who has been awaiting trial since February of 2020. Boone was accused of killing her boyfriend, Jorge Torres Jr., by locking him inside a suitcase during an alleged game of hide and seek in their Florida home. It has been since 4 years since Boone was charged with second-degree murder of her then-boyfriend, Jorge Torres Jr. And in those 4 years, Boone has reportedly gone through 8 lawyers, 7 of which were court-appointed. But all of them motioned to withdraw for various reasons, including ethical differences, irreconcilable differences, or a conflict. In a latest order, a judge ruled that, quote, "It has become apparent to the court that the defendant will now permit herself to be represented by anyone," or not permit herself to be represented by anyone. This means that now Boone will have to represent herself in her own trial. That's going pro se and representing herself as her own defense counsel. So let's break this down with my guests. Still with me, Brian Buckmeyer and Wayne Dennison. Brian, she's gone through all these attorneys. They're citing various reasons of why they have to withdraw. You're an experienced defense attorney. Just describe to our viewers about client management and relations and why this may be the case right now with this Boone trial.
Yeah, so not just a defense attorney, but also a former public defender here in New York. And so I've had my fair share of clients who have not wanted me to represent them for one reason or another. Either I'm not a real attorney because I'm not paid, or just they do not like my advice. And when it comes to client management, it's their case. I always tell them that I may be the architect of their defense, but at the end of the day, they're gonna have to live with whatever I build. And so I have no qualms with them releasing me, but it does come to a point where you're saying, are you releasing me because of a difference of opinion, or because of I can't communicate to you in a way that I can advance your interests, or is this just nothing's good enough for me? Because it's better to have, it's probably to say this, it's better to have an average or above average defense attorney. You're not always going to get the Wayne Dennisons of the world. You might just end up with a Brian Buckmeyer. But that's better than going pro se, because you don't know the ins and outs of this system. And no one's going to grant you the respect in this system when you go pro se. They often say that a person who represents themselves has a fool for a client. This is not a smart move.
Yeah, absolutely. Well, anyone who had Brian Buckmeyer or has Brian Buckmeyer as an attorney is very lucky, as with anyone who has Wayne Dennison as an attorney. So Wayne, let me turn to you. This is a bizarre case. I remember when I first heard about this case, and you see that suitcase, it's just such a bizarre, line of events here, what led to the death of her boyfriend. And Boone says it was a game of hide and seek, and now she's going to have to explain that herself in many ways to a jury. What do you think about that? What do you think about the choice of Boone to go pro se here?
Yeah, I'm not sure it's a choice that she had to go pro se at this point. I think the judge said, well, we're tired of this repetitive throwing the lawyer out. I think she's going to have a very difficult time trying to divorce her role as a defendant from her role as an advocate. And every pro se trial I've seen, that has been a very difficult juggling act for the defendant. And although she's not entitled to any special deference because she's going pro se, judges generally give pro se clients or pro se defendants and pro se clients a little more leeway, but it appears that this judge has had enough of her.
No, absolutely. And Brian, you're going to be leaving us at the top of the hour, so I want to give you the last question here before we go to break. What do you think about this case? Bizarre set of facts. How do you think it's going to end up turning out? I know we're early, but what do you think?
Very bizarre set of facts. I think the reason why she's gone through so many defense attorneys is each one has told her that there isn't much of a defense here, probably presenting opportunities to either take a plea or argue in a certain way that may be morally or socially not something that she wants to admit to, but legally may advance her case in terms of reducing the amount of jail time. And I think the writing is on the wall, and when she attempts to represent herself, she's going to realize that come verdict time.
No, absolutely. Brian Buckmeyer, always a privilege and an honor to share this set with you. We're going to be taking a quick break here at Law&Crime. Wayne Dennison is sticking with me for the next hour, so stay tuned here at Law&Crime. We'll be back after the break. Okay, welcome back to Law&Crime. We are now going to listen to some more of the arguments made yesterday in a hearing to dismiss the charge of involuntary manslaughter against defendant David Swift. Swift was charged in the murder of his late wife, Karen Swift. She disappeared back in 2011, and her body was found abandoned at a cemetery 11 years later. After his wife's death, David was charged with premeditated first-degree murder. However, a jury acquitted David last month on all murder charges. The jury was hung on his voluntary manslaughter charge. Let's head back into court and listen to some more of their arguments.
What you are saying is that once the jury returned not guilty verdict on the offenses for which the statute of limitations had not run, the case was over with.
Yes, sir.
There is no further, there's no return to pretrial indictment status. There's nothing that saves the case at that point.
That's exactly right, because it is. And that's the language that's used by our appellate court in Seagroves and also in Pearson. But it gives the language that we have a substantial right that the statute limits, and the right creates an absolute bar to the prosecution of a criminal offense after the expiration of the period designated by the statute, which in this case, for the two most serious, well, the ones that they did the post-superseding indictment are C felonies. If you look at the statute in 2011, Judge, the statute of limitations for C felonies was 4 years. You have to use the statute in effect at the time of the offense. And basically it deprives, in Seagroves, it said it deprives the court of subject matter jurisdiction. And it makes them not actionable. And it says here, because the period of limitations has elapsed and ceased to be a punishable offense, no court was then authorized to pronounce a sentence against the person who committed it. That's exactly what is in the decision. And so once the ones that jeopardy attached were over with by not guilties, these were not actionable. And so for that reason, and the state doesn't get to go back afterwards, after a trial, after this has occurred, and say, well, we're going to present a new indictment, a post-superseding indictment, which they could have done before. They don't get the right to do that. And there's also an issue with Rule 8, the one I filed Monday morning, that talks about this issue. And there's a decision attached to it. The Seagroves talks about it. Pearson talks about it. Now, in Seagroves, it says, which is an earlier decision, you don't have subject matter jurisdiction once the statute doesn't apply. But Pearson sort of changed it. It didn't take it away. It said the defendant's got to knowingly and voluntarily waive it. But it upheld the decision in Seagroves and the fact that the statute of limitations has got to be complied with. Jeopardy attached. These were not actionable. The state had not done anything before to amend it. The statute of limitations had expired, and so it's over with. Now, that's our position on the first one, and it carries over, I submit, to the second one.
Okay, let's break this down. And with me right now in the studio to chat about this is criminal defense attorney Daniel Jackson, and still with me, trial attorney Wayne Dennison. Daniel, I want to start with you. Okay, defense arguments right there saying the prosecution, you're done. You had an acquittal on that top count. Now you're trying to come back with a voluntary manslaughter charge, but they're saying, no, it's the statute of limitations that's gone. You don't have the ability to come now and try Swift with that charge. What are your thoughts about that argument?
I think it's a very colorful argument. And I think that, this is why we see, especially in places like New York, where prosecutors will charge everything up front so they don't have this issue on the back end if something doesn't go their way during trial. And I think he's absolutely correct. They had plenty of time to amend the indictment to add these charges. They chose not to. trial didn't go the way they thought it was going to do. And so I do believe that under the Tennessee law, it looks like they may be up. The statute didn't toll. It doesn't seem like it's tolled. And then therefore it will be prejudiced against him for them to try to indict him now.
Yeah, and Wayne, you have this trial that occurred. Your post-verdict, you got a mistrial with a hung jury on that voluntary manslaughter charge. You're the defense. How are you looking at this case? Are you looking at it on the level of confidence? And if the prosecutor is able to get back into that courtroom and try David Swift on the voluntary manslaughter charge, how are you generally feeling in terms of your confidence if you're going to go through that trial again?
I think you're going to enter that trial with some level of confidence. The principal charges, the intentional murder charges, were not sustained in the prior trial. Neither were the lesser included charges. And you're talking about evidence that is many, many, many years old. And in order to get to some inference of voluntary manslaughter, you're going to have, I think, something beyond the fact that the decedent filed for divorce 3 weeks ago, 3 weeks before she died. It's a very, I think it's a very difficult case for the prosecution to ultimately prove.
Right. Well, let's talk about the prosecution now and listen to their arguments in this case in response to that defense motion. Let's take a look.
Whether it was a superseding indictment or a new indictment, the defense has more than enough time to prepare for the case. The court also stated that the state did not file the superseding indictment to harass or intimidate the defendant. Also, that the appellant had plenty of advance notice of the charges against him, and the additional language in the superseding indictment did not change the substance of the original indictment. And that is the same thing that we're arguing here. This language does not change the substance of the original indictment. Still the same substance. The only difference was the tolling language. In our case, we did not file the indictment to harass or intimidate the defendant. Your Honor, and as a matter of fact, one of the reasons, in addition to the tolling language, that we felt like we needed to do a new indictment was to clean it up. Because if we go back for a second trial, I'm required to read the indictment to the jury. The only thing I would have been able to read to them is premeditated first-degree murder. And then there would be confusion about, wait a minute, I thought we were here for voluntary manslaughter. So it was also to clean up the indictment so that we could read the correct charges that we were attempting to prosecute to the jury. Your Honor, as far as collateral estoppel, the 11th Circuit also dealt with that issue in Schenberg. And the court said that there are two steps that the court must inquire about for collateral estoppel before it will apply. The first is that the court must examine the verdict and the record to see what facts, if any, were necessarily determined in the acquittal at the first trial. And second, the court must determine whether the previously determined facts constituted an essential element of the mistried count. Your Honor, in this case, the defendant was acquitted of premeditated first-degree murder, second-degree murder, also the attempts for both of those. And Your Honor, for those, for first-degree premeditated murder, you know that it's premeditated and intentional killing of another. For second-degree, it's a knowing killing of another. For voluntary manslaughter, it's the intentional or knowing killing of another in a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. And then we also indicted aggravated assault, which is the intentional knowing or recklessly causing serious bodily injury to another. Your Honor, we would also assert that there are additional elements required for voluntary manslaughter that are not required for first and second degree murder.
Okay, let's talk about the prosecution's argument right now with my guest. Still with me, Wayne Dennison, trial attorney out of Boston. And here with me in the studio, I got Daniel Jackson. She's a defense attorney. Daniel, I want to start with you. What's your take on the prosecution's argument there? Of course, they have a superseding indictment. This time, he claims that he is cleaning up the indictment, got rid of the charge which the defendant Swift was acquitted on. That was a premeditated first-degree murder charge. Now you got voluntary manslaughter. He didn't want to confuse the jury. That's what he's saying. What is your take about the prosecution going in, getting a superseding indictment, and now trying to proceed on that lesser included?
As soon as I heard that this was happening, the first thought I had was, how hasn't jeopardy attached on those charges? I do think that under Tennessee law, it does seem like the elements that they use, or what the elements they were trying to prove up in the first trial, were very similar to what they're now trying to go back in on. I know that he's now stating that the elements are a little bit different, because now it sounds like he's trying to go from either a reckless theory or a crime of passion. But we have an attempt was on the indictment, so an attempt to do an intentional act that was there, or attempt to kill someone. I just don't see how there's just so much going to be different in a second trial from the first, and I just don't see how double jeopardy hasn't attached with this fact pattern.
And Wayne, two words that are fatal to a prosecutor bringing a case again, double jeopardy, right? That's a no-go. You can't retry a defendant once double jeopardy has attached, or bring charges once double jeopardy attached. And also collateral estoppel, which is a legal concept where you can't necessarily litigate a case where there's been a fair opportunity for the parties to do so. It's the same set of facts, et cetera, et cetera. There's a few elements to collateral estoppel, but that's a word maybe our viewers are not so familiar with as opposed to double jeopardy. Can you explain what collateral estoppel is?
Sure. If a specific issue has already been resolved with a full and fair hearing and opportunity to prove your case, that specific issue, if you've lost it as the prosecution, or if you've lost it in a civil case, if you've lost that specific issue, you're not allowed to retry that issue. And as long as that issue is clean and there's a final judgment with respect to it, then you don't get a second bite at the apple on the same issue. And the point that Danielle was making is, even as the prosecution read those elements, that intent element appears to have been resolved against the prosecution, and therefore they're collaterally estopped from trying an intent crime again relative to this decedent's death.